Well, we're past 10:15, so I want to respect everybody's schedule, so we all have adequate time to hear from our speakers. So if you would take your seats, please. Thank you. Thank you. Um, Our next speaker is Professor Mark Rothstein. He's chair of Law and Medicine program at the University of Louisville School of Medicine and director of the Institute for Bioethics, Health Policy, and the Law. Professor Rothstein is one of the leading authors on the subject of bioethics, serves as the editor of the American Journal of Public Health on bioethical issues, writes a regular column on bioethics. Many of us have read his writings over the years in the Journal of Law, Medicine, and Ethics. So it's a real treat to meet him in person and having him here today to give us an overview of the policy issues that are created by the subject of precision medicine. He is asked, and I think this will probably be the kind of the protocol for the rest of the day, that we save the questions till the end so that we can concentrate our time and get a nice colloquy going in the final, say, 10 minutes of each session. The other way works, but it does disrupt the flow of the presentation, and I think we had to shorten Dr. Hutter's presentation because of that. So we respect your questions, we crave them, we like your comments just as well, but let's try to hold them till the end, and then we'll pass the microphone so everyone can do that. So please welcome Professor Rothstein.
Thank you, Peter, and good morning, everyone. I want to thank Max and Peter for the kind invitation to be with you this morning. I want to talk about issues that were suggested but not discussed, of course, in the last presentation. And one of the things that I want to talk about and try to make this clear from the title of my talk is that I'm not talking specifically about the Precision Medicine Initiative. I'm talking about precision medicine as a new way of looking at medical problems and in practicing medicine. So I want to stipulate at the outset that precision medicine approaches have been dramatically successful for certain rare disorders and in cancer treatment already, but I'm not so sure about this general approach at the present time. I want to talk about other patients beyond those two that I mentioned, rare disorders and cancers. I want to talk about how we are creating new information and how that information is going to be used. So here are the three kind of organizing principles around my talk this morning. And these refer to the characteristics that I see of precision medicine. Number one, the intent to make it patient-centered, the fact that it is information-intensive and uses big data techniques, and third, that it's resource-dependent. So the first thing I want to talk about is the physician-patient relationship and how this might be affected by precision medicine. Precision medicine, at least in theory, envisions a more complex and closer relationship between physicians and patients, where patients would be the source of increasingly granular health and health-related information, but also would be the recipients of more information about their own health in a much more granular form. And one of the ways that precision medicine envisions doing this is through patients using health apps and patient portals for greater access to their collected information. So the question first comes up, I think, is would this be viewed as a welcome development by physicians? And regardless of a physician's philosophical or professional views about whether this would be valuable in the abstract, one of the things that we have to recognize is that modern medicine is often practiced under unbelievable time constraints. And if we are now saying that physicians are going to get as well as give and explain many more things in many more details, do they actually have the time to do that? In some cases, the reaction to electronic health records has been for physicians to work longer hours and partly without any compensation for doing that, for updating EHRs after all the patients go home, for corresponding with patients over weekends and so forth. Um, if precision medicine expects those kinds of behaviors without the payoff down the road, and I'm not talking about money, I'm talking about significant changes in the outlooks and the prognoses for patients, I'm not sure that's a good idea. If we are encouraging patients to come with a bigger stack of printouts from the internet to each office visit, I'm not sure that would be looked upon really favorably by all of my colleagues in the medical center. And one of the other concerns I have is that precision medicine is promising things that it can't deliver. And one of the things that it can't deliver is this new relationship. And we ought not to be promising that. So this slide deals with the practical limitations. There are probably around 1,000, maybe 1,200 clinical geneticists still practicing. That 1,500 figure reflects all the people who've been board certified over all time since they started doing that. Fewer than 4,000 genetic counselors. So what we're going to be seeing are internists and primary care physicians forced to take up more and more of the responsibility for learning and explaining and working with genomic and other related data for their physicians. And it's very time consuming. This study that I mentioned, that's the time per case that came out earlier, that came out last year, said that only about 25 to 35% of time that they spend on a case is face-to-face. The other 2/3 or 3/4 of the time is doing the research because all these people that they see, they have different kinds of sequence variations and different kinds of health conditions, and it's not clear what to do for each one. And the field, as you all know, I'm sure, is changing so quickly. Well, a concern that I have is that precision medicine might exacerbate health disparities. And I raised just two of them on these slides. Will it increase the gap between the haves and have-nots, that is, economically speaking? And will it increase the gap between the least and the most sophisticated healthcare consumers? 2 points I'm going to refer to later on. Will precision medicine, in particular, present hurdles for these kinds of vulnerable patients? Patients who lack health literacy and health numeracy or computer fluency. I mean, if you go through the clinics in my medical school, we have patients who don't understand the difference between taking 2 pills once a day and 1 pill twice a day. And now we're going to present them with sequence information with hundreds of variants of unknown significance, with various information that is going to increase or decrease risk or affect lifestyle decisions or medication decisions, and they're going to have absolutely no clue what to do. And we may not be helping them by providing them information that is confusing and not in a way that they can get a benefit from. Even the most sophisticated, educated people, when they're ill, physical illness, mental illness, or just simply old age, are not going to be able to process that information. And how are we going to tailor precision medicine to deal with their particular needs? Then you get to people who don't speak English as their first language and are barely able to understand what their physicians are telling them now, and we're going to be ratcheting up the complexity and the sophistication of the information that we're giving back to them. And then for immigrant communities, there are cultural obstacles in many cases. So we're now envisioning a closer relationship, this give and take relationship between physicians and their patients. And we've got many patients who come from a cultural tradition where physicians are authority figures and you don't ask them questions. What's one of the things we sort of push our patients to do? Yes, it's okay, it's expected that you ask questions. It's not disrespectful, it's not violating anything. And now when you get to genomics and proteomics and all these other things, who knows? Well, one of the other things that is contemplated as a source of information is the greater use of patient portals. And this was a way for patients to gain access to their health information. And originally it started as, well, you just have a password to get into your raw medical data. And now this is the more theoretically patient-friendly version of a patient portal. Now, keep in mind, one of the problems that we see is patient portals under the requirement for, the High-Tech Act in terms of meaningful use do not have to be handicap accessible, which means they do not have to have image enlargement for people with vision impairments and so forth. Section 508 of the Rehab Act does not explicitly apply here. But let's just take a look at, you see all these icons, and so superficially this, you might say, well, this is really patient-friendly. Well, let me just highlight a few things. The medication, somebody may be taking Zestril and 9 other pills and have no idea why they're taking each one, and this doesn't really tell them. This is amusing. You can't see this because it's so light, but they give weight in kilograms, right? How hard would that be to give somebody their weight in pounds that they might actually understand it? And then they've got this thing that says essential hypertension active, and how many people are going to say, excellent, right? I've got that essential hypertension. Must be because I'm active. And they have no idea what any of these things mean. Another drug, and then numbers, potassium level. What's the average person going to do with that information? So if we really believe in the use of this technology, we have to do a better job of making it accessible to more people. Another concern is that we're going to be generating so much information about risk of all these later onset disorders. You're more likely to have this and more likely to get that and so forth, that we're going to be creating a society of worried well people. They're going to be constantly monitoring all their biological measuring devices in real time. They're going to, be able to go to every grocery store and check out the latest epidemiology of all the ingredients and all the things that they might possibly be considering getting. They're going to have wearable clothing devices with smart attachments. And is that going to be, just a good thing? You may have seen the study that came out earlier this year. People who had sleep trackers because they were wanting to measure their sleep couldn't sleep because they kept monitoring their sleep trackers. That is, if you think about that as a strategy and think about precision medicine, that may not be the way we want to go. So I think that the prospect of a society of worried well is very worrisome, and I'm worried about that. And so if for nobody else's sake, just for my sake, lowering the level of worry would be very helpful. Okay, so the second thing I want to talk about is the fact that precision medicine is really committed to big data principles, to scoop up all information that's arguably health related and put it in a big pile somewhere, and then someone is going to come up with magically an algorithm using information about your geolocation device and how many steps you've taken every other Tuesday, and produce information that is going to be meaningful in value to your current or future health. I think the evidence does not exist that most of these kinds of data points can be used. There are certain things that are valuable, but getting everybody's information about every second of every day, where they've gone, what their exposures are, how many times they've sneezed in a particular day, is not going to be particularly valuable, and yet we want to get this stuff. So perhaps you saw this study last year from the University of Pittsburgh. They studied people who used Fitbits and other sorts of things, and using them resulted in less weight loss over 24 months from a control group of individuals who did not use them. And so without any evidence that this is valuable in terms of research, we're now committed to using this information. Well, the total number of types of information that can be used for a health purpose is virtually unlimited. So I put on this slide some of the health sources of information. Family health history, of course, is traditionally been received, so you'd want to get that, and all their vital statistics, the military service records, employment records, consumer purchasing and financial information. So every time you purchase something, especially you use a credit card or a discount card or something, people are scooping that up now, they're marketers, and now we're, in addition to that, going to have that in your medical files. Educational records, every time you visited the student health service in college, it's never going to go away. It's electronic and it's going to be used. Travel and geolocation, social media postings, plus all the government records that you have, conceivably could be part of this omnibus health record that's committed to the principle that all new information, all new data are valuable, and that could possibly result in some improvements to your health. Clearly, one of the answers that you get from researchers, if you ask them the question of why do you need this, they will say, well, we don't know that we need it, but who knows what's going to be valuable, right? So the more stuff we get, the more chance there is. I think there's a threshold showing that it's of plausibility, either biologically or epidemiologically or some other way, before we grab all this information. So then you get to sort of the philosophical point of whether people are merely the sum of their data. And there are groups such as Quantified Self and other groups who this is their mantra, that they want more information. And there's no such thing as bad information and they want control of it. And the problem is they can get the information maybe, but they don't have control of it, because that brings up the issue of privacy. Now, in the last talk, we talked about the security implications of the PMI. I'm not talking about security. I'm talking about privacy. I'm not talking about hackers or unauthorized people getting access to information. The number one privacy concern that I have is that people with a legitimate need to know some information are getting more information than they need, and there are no restrictions at all about this. So let me give you a typical example. If I apply for a job this afternoon and I want to work at the airport as a baggage handler or something, I'm going to be asked, because it's a physically strenuous job, um, to consent to a medical examination, and as part of that, I'm going to be asked to sign a HIPAA-compliant authorization so that the company can get access to my medical records. Now, there's a legitimate reason for them to want to have that. The problem is that my medical records might include things that are not relevant to my ability to move a suitcase from point A to point B. It may involve things that are 20 or 30 years old, or things that I certainly don't want to share with the rest of the world. And you can imagine things that people might have in their files: a history of STIs, a history of mental health treatment, a history of all sorts of things. And because of electronic health records, they never go away. And who gets access to them? And the answer is, certainly in the case of employers, after a conditional offer of employment, for those of you who are familiar with this, under the ADA, they can get legally everything except genetic information because of GINA. So 10 years ago, I was still interested in this issue, and I wanted to try to quantify how many of these compelled disclosures take place in every year in the United States. So I apologize for this slide. It's got a lot of stuff on it, but I'll try to explain it to you. Along with a colleague of mine, Megan Talbot, in 2007, we tried to figure out how many disclosures of health information took place in these 11 categories. And I want to basically go through this for you. 10 years later, interestingly, there has been no other paper written on this topic about how many millions of compelled disclosures there are in the United States. And we thought it was time to update our study. So we are publishing, it should be out any day now, in the next issue of the Journal of Law, Medicine, and Ethics, in my regular bioethics column, the update. Because you think about it, in the last 10 years, we've got the Affordable Care Act, we've got the HITECH Act, we've got GINA, we've got consolidation in the healthcare industry. There are a lot of things going on, and we thought, well, maybe we should update our figures. So let me briefly explain this. So the first category, the largest number, employment entrance examinations. And I'm skipping some steps to get to this number, but basically you take the number of offers for employment, and then you get the number of people who you think are likely to have medical examinations. And then the discount number is, well, of the people who have medical inquiries, what percentage are going to be required to sign this authorization? So we took these numbers and had, took a 50% discount. So we estimated in 2007 that there were 10 million disclosures. Now it's slightly more because the more people are being hired. Fine, you understand that. Individual health insurance applications, an interesting one. There are about 1.1 million of these, resulting in 550,000, and now it's zero, right? Under the Affordable Care Act, you can't get that information, so you can't ask someone who's applying for an individual health insurance policy to have a medical examination, et cetera, et cetera. So 50% of zero is zero. And it's interesting that if the Affordable Care Act is amended or worse, we're going to go back to a number like this, because health insurers now have a financial interest in not granting individual policies to people who are likely to need them. Then you go to individual life insurance applications. We estimated that there were about 6.8 million disclosures here. One of the things we found was that there are a lot of changes now in the insurance industry, and the number of life insurance policies written has declined substantially for various reasons. So now this is 10 million down to 5 million. Also, the long-term care insurance market is a lot less than it was 10 years ago. And the reason is a lot of insurers left this market because they couldn't make any money in it for all sorts of reasons I can talk about if you want. So in long-term care, we're down to 130 to 65,000. Individual disability insurance has actually gone up. Disability insurance claims now, here for the rest of these, it's 20% because to file a claim, you automatically have to have, right, your medical records as part of it. They want to know that you're disabled. So that's gone up. Auto insurance claims gone up slightly. Social Security disability insurance gone up slightly. Workers' comp has decreased precipitously for reasons that people don't know exactly. One reason is a lot of claims are filed in construction and manufacturing, and those industries have gone down in the last 10 years. But at any rate, workers' comp has gone down. Veterans' disability claims have gone up, and personal injury lawsuits have gone down substantially, and there are a lot of theories for this. One is caps on damages and procedural things and so forth. At any rate, one of the interesting things is we added up, we had 25 million, and we still have 25 million with everything going up and down. It's amazing. We didn't doctor these figures. It really didn't matter what the number is. If it said 22 million or 30 million, the point is that lots of people are required to give up their privacy. And there's no way of limiting the information that gets out. So in other words, if you have a lawsuit involving, let's say, an auto accident and you're injured, 90% of your health record may be totally irrelevant to the broken leg that you suffered in an auto collision. They get everything because they're allowed to get everything, and there's no feasible way at the moment. We haven't invested in the technology to promote the privacy of individuals. And the poor excuse that we have in the United States for a health privacy law, the HIPAA privacy rule, is of de minimis value. And I could speak all day about the privacy rule, but I won't. Some of the main problems with a privacy rule are that it has limited coverage. It was never intended to be a comprehensive law. It was designed to be a check on the electronic transfer of medical records and medical information in the payment chain. So that's why the covered entities are health plans, health providers, health clearinghouses that sort of manipulate the data, and more recently, their business associates. It doesn't apply to everyone. The protection doesn't follow the data. It depends who has the data. So once information goes to someone like, let's say, a life insurance company that you've given lawful authorization to, they can do pretty much whatever they want with the information. And there are numerous exceptions, and I will sort of go over those briefly because I've got a captive audience, and HIPAA is one of my obsessions, I'm afraid. So when you sign up or show up at a new healthcare facility, often you're asked to sign something that's not a consent form. It's an acknowledgement that you've received or at least been offered a notice of privacy practices. And the first thing they say is, for treatment, payment, or healthcare operations, we will use your PHI. We're just telling you this. We're not asking. We're telling you this. And for two of these, payment and healthcare operations, they are pledging, because the rules require that they only disclose or use the minimum necessary for the purpose of the disclosure. That doesn't apply to treatment. But the thing that's interesting to me is that there's no requirement that the disclosure be in the least individually identifiable form. So let me just tell you a story about the payment issue. I teach at the University of Louisville. Louisville is the home of Humana, and over the years I've had literally dozens of Humana employees as students in my class. Either they're PhD students or MPH students. They're usually sort of middle-level management types. And one of the things I always ask them is, if I file a claim, how many people are going to see my health information? And they say between 100 and 150. And I say, and it's in individually identifiable form, right? Oh, yes. And then I ask them, do you really need the information to be individually identifiable form? I've got a membership card that I have a 14-digit patient identifier. There's a 12-digit employer identifier. There's a 9-digit code identifying what plan I have. Couldn't you just use that number? By the way, I don't have Humana, but I'm just... oh, yes, sure, we could use that number. That wouldn't be a problem. So, well, why don't you? Why do you still use and require individual health? So, well, let me explain it to you. Number one, we're not required to, in effect, de-identify the information, not the 18 HIPAA things, but I mean just taking somebody's name off. We're not legally required to do that. It would cost us a little money at the start by changing some of the, we'd have to, rewrite some of the code and stuff. And in a rare case, we might have to look something up and really find out who it was. So there would be a little cost. We get no pressure from the government. We get no pressure from any of the payers, like the employers who buy Humana plans, and we don't get any pressure from the patients. So why should we do this? Because you're concerned about this? If you want us to be concerned for the course of this semester, you think it's going to be in our grade interest, we're concerned. But when we leave here, we're not concerned anymore. The point is, privacy is not free. It costs. The question is, are we prepared to pay those costs? And here are the public purpose exceptions. There are 12 of them. And the important thing to remember here is this says that these disclosures do not violate the privacy rule. It doesn't say that these disclosures are required. They're permissive. And the obligation to make one of these disclosures comes from somewhere else. So for example, every state has reportable diseases, right? So if you have a patient with a reportable disease, you have to report that to the health department, and doing so doesn't violate the privacy rule. But the privacy rule doesn't say you have to disclose it. Another example would be the Tarasoff to avert a serious threat. The privacy rule says you can disclose it, but whether you have a legal obligation to disclose it depends on either a statute or common law principle that's at work in your state. So Tarasoff has two elements, right? It's the permissive element, and then there's the duty. At any rate, the three things that I put at the bottom here were, is there anything left that there's not an exception to? And that's it. That's it. So let me get back to precision medicine. The question is it a good idea to amass all of these new data sources and compile them in a clinical record when we don't have adequate security or privacy laws? And I would say no, but that's not the unanimous view. So here's a quote from Larry Page, co-founder of Google. And I'll tell you what bothers me worst about this quote. It says it's these things. That's what bothers me the worst. These things are my career. I care deeply about privacy. My office is a block from Louis Brandeis' child at home. I breathe the Brandeis air. Um, I think privacy is really important, and it's not these things. Um, and if we did, he claims, in other words, do more data mining of health information, we'd probably save 100,000 lives next year. How should I say this? I think that's one of the least enlightened statements I've heard in this area, and one of the least humble statements I've heard. What we're going to get from most of these large big data applications are correlations between A and B, right? We've got lots of correlations that we haven't been able to do very much about. We've known for over 50 years that cigarette smoking is not particularly good for you. Unfortunately, our treatments for lung cancer are not that great. We've known for over 70 years, roughly, the genetics of sickle cell disease. We're not really much closer to curing that. This is not going to prove that. We could do all the data mining we wanted. One of the things we might find is that people who have XYZ genomic trait and ABC history and DEF exposures, et cetera, are better on drug A than drug B. Okay, that's not going to save 100,000 lives next year. In January of 2015, shortly before the famous State of the Union address by President Obama, the White House OSTP, Office of Science and Technology Policy, issued their report on big data that was unabashedly positive, that it's going to be the greatest thing since sliced bread. That came out in the end of January of 2015. The same week, this was the cover of Science. Same week. And I think there is cause for concern about all the data that we are giving off and letting people have. In two broad categories, I'm concerned about the aggregation and analysis of individual data, and in a larger sense, whether we are unwittingly marching down the path to this total surveillance, total data mining society. And now to another cheery topic. I want to talk about the lack of money in this field. So everyone's seen this slide if you've been on the NHGRI website. It's the precipitous drop in the cost of genome sequencing. And from that, many people have drawn the erroneous conclusion that the use of genomics in medicine is similarly falling off the cliff the way the cost of sequencing is, and that's not true, because the cost for evaluation and interpretation and explanation and counseling doesn't follow Moore's law. If it did, all the people holding those jobs would be getting 20 cents an hour pay. The more things that we find or things that we're suspicious about, we need to follow up with them. We need to test for them. Some of the tests are invasive. Many of the tests have to be repeated over the course of decades. And many of these tests will never show anything because people have a predisposition, but they don't get it. Or they have a predisposition and there's no value in early discovery because there's nothing that we can do for them except make them worried before they actually have symptoms. I'll talk a bit about pharmacogenomics, you heard that earlier. And high costs on this part of the healthcare economy are clearly going to affect healthcare costs throughout the economy. Precision medicine, you talked about that earlier, but clearly this is going to be more expensive. There was an article just a couple weeks ago. I don't want to go through all of these, but If you segment the potential market, you're going to have fewer people entering that market, and the fewer in the market, the more you have an ability to control the price. And the fourth one, the research and development costs are not just for the drugs, but they're also for what's called the companion diagnostics, the test that shows who needs the drugs and what the drugs later on are doing. And what effect on our healthcare system? So Obamacare, as you know, is under a lot of stress, shall we say. But even at its best, there were still about 29 million uninsured people, many of them because the states did not increase their Medicaid pools. The question then has to be, how many people are going to have access to precision medicine? So from the 29 million figure, your guess is as good as mine about a new healthcare system, how many people are going to be losing their benefits. And then on top of that, of the people who already have coverage, are these new expensive drugs going to be on the formulary? Are they, does the plan cover all the follow-up and the testing that's going to be needed? And so I think it's going to be many times more than the 29 million who are going to lack access to precision medicine. And then you get to vulnerable populations. I think that most, the people who are most likely to have trouble that I mentioned earlier are also going to least likely to benefit from precision medicine because they're not going to have coverage. So my conclusions, I think at best, adoption of precision medicine is going to have these three challenges that I talked about this morning. The ability to be truly patient-centered and information-intensive, and as well as the resource problem. At worst, precision medicine is going to waste scarce resources that could be better spent generating data that are most valuable for data brokers to use in marketing purposes, while only benefiting a very small percentage of the population. Now, let me just add another note. I think it's absolutely incredible technology that has great promise. It's wonderful for people with rare disorders, and you've probably seen all these things, as well as it's becoming standard of care in cancer. Fine, I support that, but it's not going to immediately help most people. I also think it's being based on a view of who's going to benefit that is based on a kind of a monolithic conception of this person. And this person is tech savvy, highly health literate, highly motivated, information seeking, English fluent, and well insured. That's not everybody. I'm almost done and I'll take your question. And so I think we need to consider the structural weaknesses of the healthcare system on which this is based. And I did a paper last summer. That's the first one, some lingering concerns. And the new paper with Megan Talbot will be out any day now. And then 3 months from now, in my next column is an article that sort of tracks the talk today. So we've got time for questions, correct? Okay, thank you.
Can you turn it back to the list of that when I poked my hand up to that list, resource intensive, wealth?
Okay, well, I can't.
Oh.
Somebody can. Is there anybody back there?
Yep.
Okay. Oh, there we go. Is that the one?
Yep, that's
Okay,
it.
good, thank you.
And in my estimation, urban.
Okay.
I think urban needs to
Yeah, well, that list, list was twice as long at one point. Yeah, sir.
The consideration the consideration of the patient. Uh, and, and you correctly pointed out that even the literate patient is at a substantial disadvantage via the physician with respect to information and be able to grasp the really highly sophisticated information. So in a sense, precision medicine it will be placing a tremendous, I wouldn't call it burden, but opportunity, if you will, on the physician to act as a patient advocate and to really intensify the physician-patient interaction. The thing is that I'm an oncologist and being an attorney, but as an oncologist, I can tell you that the challenge for the physician then is to be able to grasp these concepts and be able to communicate them in an effective way to patients with a variety of different educational and socioeconomic backgrounds. And there is the limitation is going to be finding enough physicians who have the ability to absorb that information in a wide variety of areas and be able to communicate that and, in a sense, be adequately compensated for having to take on that activity.
Yeah, I think it's a very good point. I thank you for mentioning it. The number of obligations that physicians are going to have going forward is staggering. So let me tell you another one that I'm concerned about, and that is if you go and have your genome sequenced today, there's a lot of stuff that we don't know what it means, right? Well, 5 years from now, when there's a study that shows what some of that means, does the physician have an obligation to recontact all those patients who had that and say, come on in, there's been a new study that variant of unknown significance, we know what that is now. So there are lots of issues. Yeah. Oh, I'm sorry.
Go ahead.
Sharona, don't mean to.
It's on. Okay. Yes, it is on. So first of all, thank you. That was great. Second, could you address, there are people who say we're now at a stage where we don't care about privacy, where everybody spills the beans on every type of social media, and those who don't write blogs and articles about themselves, and nobody cares about privacy anymore. How do you feel about that argument?
Well, actually, just did a study of that. What I was concerned about was not everybody, but the comments that I would have gotten for years is that young people don't care about privacy. You see what they post and all this other stuff. So I wanted to know whether young people versus older people really care more about privacy. So along with Amy McGuire at Baylor College of Medicine and her colleagues, we did a survey of 1,300 people and got data that are very interesting. It's under review at a journal now, but I will tell you the sort of the bottom line finding. People who are between, say, 21 and 28, that's the magical cut point. Once you hit 28 or 29, your views on privacy are pretty much like everybody else. The people who are in that range or presumably below have about a 10 percentage point difference. Even the younger people care about privacy, even though less than their elders. And then there was another question that we asked, how do you feel these groups view privacy? And everyone viewed each group as caring less about privacy than they actually do. My conclusion, and it's from the study, is that any difference between, let's say, a 23-year-old and a 43-year-old, it's not a generational difference. It's a life cycle difference. That the 23-year-old, when he or she becomes 43, is going to have more concerns. They're going to be less healthy, right? They're going to have families, they're going to have jobs, they're going to have life experiences that teach them to be wary of what they post and all this other stuff. So that if viewed in those terms, we shouldn't abandon, our commitment to privacy because it benefits everyone during their life time at different rates. So that's the study basically that we did. Yeah.
Yeah, I am a medical director of one of the FQHCs in the PMI and the All of Us initiative, and I just wanted to emphasize the points you were making, because some of our struggle is we are participating in how to develop this process meaningfully, is the amount of time and burden on providers, and the information that will come back to the participants does not necessarily come back to us as their primary care providers. And we don't have time to get somebody's diabetes under control in our population, much less having the time to educate primary care providers, which are a disappearing entity in this country because of all these demands. So I just want to, applaud what you're bringing up, because I think those of us that care about population health and the overall health of communities want to be part of this process, but are struggling in how to integrate it into these very real everyday problems that we're trying to help patients with.
Well, I thank you for that comment. I just want to say that the PMI has really emphasized, in terms of its ethics, the research ethics. I'm not worried about that at all. The people who are doing this, they're people I've known for many years and I respect greatly. The people who sign up, they're going to give informed consent and everything's going to be fine with that. What I'm talking about this morning is what are the bigger implications, not about the PMI, but rushing down this path to, total information for everybody at all times. And I have my doubts about that. So if there, final question. Yes, I'm sorry.
Okay. Thank you. Your comment that precision medicine is being developed to benefit the well-insured patient. And what does that have to say about Medicare patients? And is this going to be an age-based rationing?
Well, I mean, it's not specifically. I'm saying that it's, I think it's based on people who would get there. I don't know what Medicare is going to cover in terms of precision interventions.
I guess my view is I am a Medicare patient, and at my age I have to be Medicare. There are no other options. I can't buy a private policy. And my feeling is it's not particularly good insurance, that there are doctors and hospitals that don't accept it. So what does that do for my future?
Well, that would be,
medicine?
Yeah. Well, if individual patients became more expensive to treat based on precision medicine, I suppose you could make the prediction that more providers would say no more Medicare patients, no more Medicaid patients, more so than that, because they just, they're like lose money on each patient if they have to spend an hour talking about all these data points. So thank you very much. I enjoyed it.
Thank you very much, Professor Rothstein. We could do that, and while I'm letting them do that, we can talk about the CLE credit. Did you want to address how one gets that? If
that should have been in your packets. It's in the packet.
Okay. If there are any questions, Nancy would, or Max can answer them. We'll be back in 5. We are about to reconvene for those outside. I had the privilege of having dinner with our next two speakers last evening and learned about their fascinating careers as well as their common love of a particular French dish. So they're at least unified in one thing. They went to the same item on the menu, and I think they both enjoyed it. First, allow me to introduce Dr. Ellen Wright Clayton, the Distinguished Professor of Pediatrics and Professor of Law at Vanderbilt. Dr. Clayton has co-founded and directed the Center for Biomedical Ethics and Society and has authored a tremendous body of scholarly work ranging from children's health to the ethical conduct of research involving human subjects. Professor Clayton is also an elected fellow of the American Academy for the Advancement of Science. I will introduce him now because he doesn't need one, but I think I may miss this opportunity if I don't do it right now. Our second panelist for this next session is Professor Max Mellman, known to most of you as the director of the Law Medicine Center at Case Western Reserve University, serves both as a professor of law at its law school and a professor of biomedical ethics at its medical school. Professor Mellman has written extensively on the subject of genetic medicine and genomic bioethics, so he's particularly well qualified to organize and participate in today's programs. Both Professors Clayton and Mellman will be discussing liability issues in clinical translation. So please welcome both of the next two speakers.
Okay, well, it's a pleasure to be here, and thanks for, Max told me this would be fun, so let's see if it is. And I want to make two comments before I get going on the topic of my talk. The first is that a student of mine have just finished interviewing a number of primary care providers and other clinicians about the impact of getting whole genome sequencing results. And the prospect of doing that. And the answer is, I think that they are horrified about all the reasons that Mark said about what the impact's going to be on them, how they're going to deal with it, et cetera, et cetera. So I just, and we're in the process of writing that up. The other thing that I would mention is that I'm just finishing a systematic literature review about what people think about the privacy of their genetic information. And I don't want anyone to believe that people don't care about this. Some people don't, a lot of people do. Again, we're preparing another study for preparation as well. And if Mark's study gets out in time, then we'll include it too. But it's, this is really just a tremendous issue for us. So, but let me turn to what I was supposed to talk about today, and then we'll get on with it. I was asked to talk about two issues related to how we define duty, and having to do with the sort of notifying relatives about genetic risk and about re-examining genomic results. We've heard some allusions to this already, and let me just tell you what the punchline is here. I see that people in this particular field, particularly geneticists, are rushing to embrace extensive obligations in this area that I think are problematic. And so I'm going to talk about what the legal rules are and actually talk about what the practical implications are for your clients. So what do we mean about talking about genomics? This is a pedigree for those of you who haven't seen one. The one with the arrow is the individual who's the proband, the person who's affected. They have some relatives upstream who've already died who probably had the same thing. And so we have somebody with a disease that looks like it's probably inherited as a dominant disorder. And what's relevant about this is that there are other people who are at risk. One is the sibling of the person who has the disease, and the other is a child of the person who has the disease. And so the question is, what do you do about telling some of those people because they're at risk? So we've had some cases about this, and I just want to talk about some of what they've held and some of their limitations before I sort of move on to the next thing. And I want you to look at the date of these cases. You're welcome to have these slides if you want them. I assume they'll be shared with you. The first one was one that was decided in 1995, a case called Pate versus Threlkel, in which a woman had a hereditary thyroid cancer, and then her daughter subsequently developed thyroid cancer, and she sued the mother's doctor saying, "You should have told me." And what the Florida Supreme Court in that case said was, well, it was important that the doctor should have recognized that there was a risk to you, but the doctor's obligation ended with telling your mother, and then your mother should have told you. And I think this is really pretty much standard of care in genetics now, particularly familial cancer clinics, that you tell the proband or the affected patient that there are other family members at risk. And in point of fact, what I think is clearly the ethically appropriate course of care is to tell the patient about this particular risk, to offer to help them tell their relatives, to give them information that they might want to share with their relatives, but the ultimate goal here is not to go around your patient, but rather to figure out how to help your patient deal with his or her relatives. Recognizing that when someone's just got a bad diagnosis, they may not be ready right away to tell anybody else. In general, most people care about their relatives, and that given enough time and enough support, they will. But this is the way to go. The next case is the one that's been sort of a nightmare that was decided in 1996 in New Jersey called Safer versus Pack. And you talk about hard cases making bad law. There is nothing about this case that is good, not a thing. This is a case in which a man was diagnosed in the early 1950s with a hereditary form of colon cancer. And so what the wife alleged was that she was told by the clinician that her husband had a bowel obstruction, which was true, but it just wasn't enough. It's also the case that that particular syndrome was just being described at that time. And if you think back to the 1950s, we didn't have the doctrine of informed consent then. We had a very different notion of patient disclosure. It could have been that the doctor didn't tell the patient because he didn't think the patient would want to know, or it may have been that the doctor didn't told the patient, and the patient said, "Oh, don't tell my wife because she would be worried." course, we can't ask the doctor what he said because he was dead, and we can't ask the patient because he was dead. But the lawsuit was brought 20 or 30 years down the road by the daughter, who also developed colon cancer, and who alleged that the doctor should have told her. She was a child, a young child, at the time all of this was occurring. And the appellate court in New Jersey held that nonetheless the doctor had an obligation to tell the child. So, I mean, talk about silly and impracticable and making no sense and out of line with the standard of care. It was just silly. But it creates great consternation in the genetics community. I want to make the point that no money was ever paid. There was a lot of subsequent litigation. But the other point that I would make is that the New Jersey legislature immediately overturned the ruling. Okay? So when you have people talking about SAFER versus PAC, its precedential value is 0, in my opinion. You know, there are other kinds of warnings that people have to give. We have an interesting case in Tennessee called, and the other thing I want to say about PATE and SAFER is that they have not been followed ever. Ever. I just did a Westlaw search last week. It's one of the things I get to do since I'm a law professor. And those cases have never been cited with approval for the notion that you have to warn family members about risks of hereditary cancer. There's one potential case in the context of reproductive risk, that's Malloy versus Meyer. But the fact of the matter is these cases are 20 years old and have never been followed. So, so I think that where we're left here is actually, is actually with, the notion that what we ought to do is what we ethically ought to do, which is to tell our patients what their risk to families members are, and to offer the help them tell their families. I think that's what we ought to be advising, people. There are a couple of other bodies of law that might be brought in here. One of them is Bradshaw versus Daniel, which is a case from Tennessee in which a man developed Rocky Mountain spotted fever, and for some reason the wife said she wasn't told that. He died, and then she subsequently developed it. This is a tick-borne disease. And the Tennessee Supreme Court said that the doctor should have warned her. I think that's a harder case with regard to infectious diseases, but nonetheless it's out there. And of course, Mark referred to the case of Tarasoff, which actually is a great big, which is actually both a great big and a really tiny example of duty to warn, because the course of the law over the last now 40 years that case has been, is that the courts have been very careful to narrow the scope of that ruling going forward. So that's kind of where we are about duty to warn from a perspective of tort law. And I also, and I'm going to defer to Mark about this because he's, he is Professor HIPAA. But I would say that when people say that, you can argue about whether this is an imminent threat of harm. I would argue that one of the ways you could limit Tarasoff is that it, by and large, is generally socially unacceptable to kill people, to go out and shoot them or do whatever. We have some longstanding laws about that, going back millennia. Failing to tell your relatives about something that they're at risk of, not so much. And so, so one of the issues is, so what are physicians entitled to tell their patients? And if you look at this, what HIPAA or what the Office of Civil Rights has said is that, of course, you can tell relatives what's going on with the patient, but only insofar as it's necessary for the patient's care. It's not about duty to inform or any obligation to inform the relatives for their own care. So I think you really have to try to triangulate whether this duty to warn that Mark alluded to and this really pretty narrow scope of what the Office of Civil Rights said about HIPAA, about whether you can tell people over their, particularly over their patient's objection, but even if they don't, about what the risk to family members is. The right answer here is to work with the proband, to work with your patient. So that's the first one. Second one is the duty to reanalyze results, and Mark uh, um, referred to this as well. I have to say, Mark wrote a wonderful paper that appeared about this a few years ago, and was this in the Houston Journal? If you are interested in this question, he has written the smartest legal analysis of this around. So I'm feeling a little bit like bringing coals to Newcastle, but 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 the reason that I want to talk about this is that is first of all to make the point that that this is becoming an issue because we're doing multiplex tests, including whole genome and whole exome sequencing. And also our understanding of the clinical impact of specific gene variants is rapidly evolving. And it does absolutely mean that an interpretation that we made in 1 year might be different in the next. Now, this is, I think, really fairly scary. It's also not new in medicine, not at all new in medicine. And so how do we deal with this? So there are some old and new things that we can talk about here that may help us think through this. The old things that are out there are that we've actually seen some of this before. In the 1960s and 70s, we saw the DES cases, diethylstilbestrol, which causes clear cell vaginal adenocarcinoma. I only say that one time because I can only get it out of my mouth once. But it was recognized because this was rare as hen's teeth, like Kaposi sarcoma prior to the advent of AIDS. And so a really smart pathologist realized that all of a sudden he was seeing all these cases of something that was supposed to be really rare, and so recognized that there was this correlation, which turned out to be causal, that DES did this. And so there were a few cases that were brought that suggested that maybe you needed to track these women down. And then there were a few cases, again, going back a half a century now, back in the day when you used to radiate tonsils to make them get smaller rather than just take them out or wait as God intended for you just to grow up, which would make your tonsils get smaller. And so people were developing head and neck cancer because they had their necks radiated when they were little kids. There was one case in which it was alleged that you had to follow up these patients. There are 3 of these cases to my count, but they're nonetheless out there. In addition, there was a big debate, again within genetics community in the 1990s, that suggested that once you saw a patient, you had the duty to recontact them with new information going on into perpetuity, which is this was something that was widely debated and sort of died on the vine. And so nonetheless, this has been out there. It hasn't really been embraced in any substantial degree until now. So what's new? What's new is the Williams case in which a child had a seizure disorder. Turns out seizures are a genetic disease. We didn't know that, just like we didn't know that cancer was a genetic disease until now we do. So these are things that we know. A child had had a genetic test done as part of his workup for a seizure disorder. They found a variant which was called a variant of unknown significance, so they didn't know whether it mattered or not. And it turns out that it actually did matter. And what's more, that actually making the diagnosis of this particular form of epilepsy is really important for directing therapy because standard therapy actually kills you, which unfortunately was happened to him. What made this case particularly problematic is that allegedly the lab director had actually published an article at the same time which indicated that this particular variant was pathogenic. And so, or that could be causally related to this particular kind of cancer. And so, I mean, this case is ongoing, the last I heard. So it's unclear whether it's a duty to follow up or whether it's a failure to make an appropriate diagnosis at the time. But nonetheless, this case is out there and has caused a lot of concern. What is more interesting to me, I mean, this is a sad case, no question about it. But what is equally interesting to me is that labs are increasingly doing this reanalysis routinely. I'm a member of a couple of different research consortia, both the eMERGE consortia and the MERGE consortium and the CSER consortium, both of which are involving in how do we figure out what's pathogenic and what's not, you know, which turns out to be much more complicated than you think. And what I listen to the clinical lab saying is they go in these meetings and say, not do we have an obligation to do reanalysis, but how frequently? And so I listen to them say, do we have to redo this every 6 months? Is doing it yearly okay? But on the ground that doing it every 6 months, we're not really finding it very much. And so, but doing it yearly, maybe we're finding a little bit more. And so what I see going on in this area is that in point of fact, the genetics community is embracing this as a standard of care. And this will be a very interesting question. As we try to think about who bears the cost of this, how do you track these folks down? People are mobile, their health insurance changes from year to year, their providers change from year to year. How do you provide the decision support for clinicians to actually counsel patients about what they're learning? And it's particularly important because increasingly with these panels, you may do it for one purpose, but you may get a lot of other information as well, and deciding when that information needs to be followed up. These issues are utterly and completely unresolved. So I think this is a really major issue that you may want to be advising your clients about, because they need to be I think they need to be asking the question about if they're going to be doing this reanalysis, how can we do it responsibly? And who is actually how are we going to get the systems in place to get these results back? Because they're not there. I'll just say, even though, even though I live in one of those academic medical centers that is full bore involved in this kind of research. So, so my conclusions are these. I think these two areas have a potential to expand significantly the legal obligations of clinicians, laboratories, and even researchers who use genetic information. I'd be happy to talk about the research space, but this is an ongoing concern. And I think we're going to face tremendous challenges in deciding which of any lines are appropriate to draw. But the answer is we have to draw some. I mean, this really can't just be unlimited liability going into the future. And then finally, I have to say that this is funding in part from LawSeek, which is a large grant that we're doing to try to define some of these issues. And I should also mention just about every other grant I'm on, including 3 cycles of the eMERGE Electronic Medical Records and Research Consortium, the CSER Consortium, Clinical Sequencing and Exploratory Research, and virtually everything else. I mean, this is what I do. So I hope I've raised some questions for you. I don't know what the right answer. Well, I have a better idea about what the right answer is with regard to warning relatives. What we do with with creating this obligation to follow up is one that I think we really need to think about this more critically than the community currently has. So, yeah. Kristen.
Yeah, you can hear me. In the context of participation in clinical research, often the institutional review board or the researchers will think in advance about recontacting individuals where clinically relevant results are found in research. But in clinical care, where clinical genetic laboratory tests are ran, there's no discussion with the patients in advance about whether they would choose to receive results later. What do you think about the consent issues and how we should handle that?
Well, I think, if we're going to be doing these broad scale tests, multiplex tests, that we need to be telling people about exactly what they're buying into. And so that they have some idea about the secondary findings, which are the ones that aren't necessarily pertinent to their particular clinical question, and about this issue about following up, that interpretations may change. I mean, this is part of clinical medicine, but until now, we have not embraced the idea that we need to go back every time, re-examining all the records that we have, and then decide whether what we told them in the past was a good idea. And so, so I think it's important both for clinicians to be mindful of this and for patients to be mindful of, about what's at stake here.
I have a question, if no one else does. So Ellen, there's arguably another sort of set of legal precedents in regard to the duty to warn, which is the public health set of precedents, duty to warn about communicable disease, transmissible disease. And, and we went through this, as you know, in the HIV/AIDS
Right.
crises of the 80s in particular, and the question was, is it sufficient for the doctor to, having diagnosed a patient as HIV positive or with AIDS, to tell the patient you need to warn or behave yourself, or does the doctor have a further obligation? Those are transmissible diseases, right? That's a transmissible disease, but in a sort of sense, so are genetic illnesses, right? I mean, they are transmitted from parent to child. So what if the doctor reasonably believes that the patient won't or can't warn their relevant family members, and there are reasonable steps, not the sort of multi-generational, the doctor's dead, what do you do now contexts, but there are potentially reasonable steps that we might say the doctor could take to warn the relatives. I just wonder if you have any thoughts on.
Oh, I do have some thoughts about this. You'll not be surprised to know. So I think we have a longstanding public policy about warning people at risk about communicable diseases. When I practiced pediatrics for 20 years, if I've diagnosed a disease in one of 50 diseases, we automatically had to tell the health department, which then had the responsibility to go track people down and tell them. And, whenever we diagnosed with a kid with meninge, the whole sky would fall, and they'd close down the school and give everybody ceftriaxone, et cetera, et cetera. I don't think that, first of all, I think that genetics is different from that. I mean, the risk is similar, but I think that the possibility of intervention is different. And that also we don't have such a clear statement of policy that, that we're going to have to go out and warn family members just because I have a germline mutation in BRCA1, which I don't, thank goodness. And I think that if you're going to go out and reach out to relatives, then I think at a minimum, I think you ought to do that with fear and trembling. I actually believe in privacy and confidentiality. I believe in the confidentiality of the physician-patient relationship or healthcare provider-patient relationship, right down to the tips of my toes. I believe that, and I think if you're going to do that, I think at a minimum, you need to tell your patient that that's what you're doing, and I think you need to say, I disagree with your unwillingness to tell your relatives, and I'm going to reach out and do it. And I, I, I think that's, uh, I think that's where well, actually, that's where I've been on this particular topic for 25 years. I wrote my first article about it in 1990. I mean, not 1990, 2000, so it's only 17 years. Sorry. Um, but I have seen no reason to deviate from that. I really believe in the sanctity of the relationship, and I think patients have to be able to rely on that.
In the early 90s, this is a follow-up to your last answer. You'll recall that the ASHG Social Issues Committee issued a position statement on this issue, whether there was a duty to warn other people, and Ellen and I
We're on it.
chaired it at the various stages. And the committee came down with the position that generally not, but in the rare situation where it was immediately life-threatening and there was something to do and all this other stuff, I objected to that language, which I thought would be possibly open-ended in the future. But at any rate, there was just a very narrow exception in the ASHG policy. But that was pre-HIPAA. To the extent that there was an exception that people recognize, that's out the door because there is no exception under the privacy rule, and the duty to warn provision there was, that I mentioned in the 12 public purpose exceptions, was specifically for the Tarasov situation where you had a patient with a mental health problem that was making threats against an identifiable victim. That was it, and it was not intended to include this matter.
Just a quick follow-up on that. It's interesting, the Office for Civil Rights has actually issued interpretation that the treatment exception doesn't apply simply to the patient whose information is generated. It would also support the treatment exception would support the disclosure to a family member if it is for the treatment of the family member. I don't know if that's a good outcome or not, but they have indeed issued that interpretation of their regulations.
But I think you as a clinician, I mean, I just think that's a nightmare. So just.
But is it a worse nightmare than the kid who could have avoided, a horrible death because their parent really didn't have a good relationship with them and didn't want to have anything to do with them, including telling them about something that they could have responded to? I mean,
I think that's really rare, Max, and so.
Well, that's good. I mean, that's good. But in those rare cases, I mean, if you have an absolute standard in the law, what about those rare cases?
I think what you do is that you have to face up to the full responsibility of what you're doing. And you have to tell your patient what you're doing. I mean, they're always really difficult cases. But, but what yeah. Okay.
I find it odd, ironic almost, that here we are sitting in a room talking about patient-centered medicine, individualized medicine, and what you're talking about is not a single, it is a genetically joined family. And it's just a statement, but in healthcare, when one person in the family has cancer, the whole family has it. And I covered Jerry, when one person in the family has Alzheimer's or whatever, the whole family has it. So what I see is real tension here between individual and family. And nobody's actually articulated that. I've solved that problem, however.
Well, I guess here's how I would respond to that. I couldn't agree with you more. I'm a pediatrician, so, Every time a kid is sick, the whole family is sick in a variety of ways. I think the question from a legal perspective, in my view, from an ethical perspective, of course you want to think about dealing with the whole family, and of course you want to think about, but your primary focus is on the patient and helping them with helping them treat their problem and helping them work with their family. But as a legal duty, I think your obligation is to the patient. The question is, when you take a cancer patient into your care, for example, or I guess you do Alzheimer's care, I gather, does that mean that you suddenly become doctor to the whole family? That's a separate legal question from the ethical question. Right, but I think that you have to work with your patient on that and not say, and by the way, even if you patient object, that it doesn't matter to me that you object. I just am going to tell your family. I think that's a separate legal question.
Thank you very much, Dr. Clayton. Excellent. Great discussion, really super. To be followed by another great presentation from Professor Millman.
Thank you. And while we're loading my slides, Ellen, there's, the bringing up the HIV/AIDS analogy raises an interesting question, and maybe this is something that should be a public health matter. And so what the doctor does is report the finding to the public health department, and they have to figure out who to warn. But that's maybe too provocative. Okay, so what I'm talking about is, well, but that bothers me, as it did during the HIV/AIDS, the height of that epidemic. Anyway, that's not what I'm supposed to be talking about, though. I'm talking about practice guidelines and the legal standard of care in precision medicine, or more specifically, what should the role of practice guidelines be in cases in which healthcare professionals are alleged to have violated the standard of care by not properly practicing precision medicine and as a result caused harm to their patients? And this is a topic that the topic of practice guidelines and the legal standard of care is a topic that I originally researched with funding from the Robert L. Haybush Foundation of the American Association for Justice, in the interests of full disclosure. So what's a practice guideline? This is the generally accepted definition, although it's old, it's still good, from the Institute of Medicine, systematically developed statements to assist practitioner and patient decisions about appropriate health care for specific clinical circumstances. And, doctors have always given one another advice, tips, suggestions, consulted, the curbside consult on how to care for patients, but formalized recommendations called practice guidelines really began to emerge in the 1980s and initially generated a great deal of enthusiasm. This is renowned health policy expert David Eddy, who predicted that practice guidelines have the potential to affect the quality and cost of medical care more profoundly than all the new treatments of the past or next decade. And the first kind of well-known practice guideline was this anesthesia guideline. I apologize, the type is a little small, produced by Harvard anesthesiologists in 1984. Actually, this was published in 85. And this arose from concerns about the number of patients who were dying under general anesthesia in surgery, and a 2020, that was a television show, I don't know if it's still on, expose of this. Rapid increases, or unacceptable increases in the malpractice insurance premiums for anesthesiologists. So a group of Harvard anesthesiologists got together and came out with this guideline. And one of the things it said, I just picked it out of the rest of them, every patient shall have arterial blood pressure and heart rate measured at least every 5 minutes. And I don't know, apparently this wasn't being done routinely. But once this was promulgated, apparently the anesthesiologists followed it, and deaths dramatically dropped. Malpractice insurance premiums also, as you might expect, dropped precipitously. So this looked very promising. And expert witnesses began relying on practice guidelines like this to support their opinions about whether defendants met the standard of care in medical malpractice cases. This is a analysis of reported cases from 1995 to 2011 and shows the number of times that expert witnesses for the different sides, or in some cases for both sides, referred to practice guidelines as support for their expert opinion about the doctor's compliance with the standard of care. And that's fine, because the experts might disagree. They might be referring to different guidelines if there are more than one guideline that might be applicable, and it's left up to the jury and or judge to decide who is right. But in the late 1980s, interest grew in making practice guidelines the conclusive legal standard of care, so that doctors who followed them could not be held liable for poor outcomes, period. And they could not be second-guessed, and the jury could not find otherwise. And more recently, under the Obama administration, in fact, this approach would be called practice guidelines safe harbors. So the idea of a doctor being able to defend herself conclusively by showing that she followed a practice guideline, and that would be a safe harbor. In 1990, the state of Maine enacted, the legislature enacted a program to establish practice guidelines as the conclusive standard of care. Practice guidelines were developed by several medical specialty societies in the state, and a physician who showed that she followed a guideline could not be found liable for malpractice. And interestingly, the guidelines could only be used in one direction, that is, only as a defense. A plaintiff patient could not introduce the failure to follow a guideline as any evidence whatsoever of not meeting the standard of care. And we can talk more about why they did that or not. But organized medicine was not entirely, you might think, doctors would jump on this as a great way of protecting themselves for malpractice liability, but organized medicine was quite skeptical, and this is the then president of the AMA who said, you cannot restrict physicians to one procedure or series of procedures for a specific condition. No two patients are exactly alike, and no two conditions are exactly alike, which sounds awfully like precision medicine that far back, right? And indeed, it's hard to imagine how a practice guideline could serve as, or most practice guidelines could serve as definitive standards of care, because the guidelines tended, if they were well constructed, tended to acknowledge Todd's concern. So I didn't give you the full language of the anesthesia guideline, because after it said you should do it every 5 minutes, it went on to say unless clinically impractical, which means do it every 5 minutes unless you shouldn't do it every 5 minutes, given the specifics of the patient's case. So imagine a doctor trying to assert adherence to this guideline as definitive standard of care. Well, was this a case in which it should be done every 5 minutes, or is this a clinical impractical exception, right? Now, precision medicine seems to reinforce this notion, right? Here's a statement about a description of it. Instead of relying on generic practice guidelines, your doctors may one day use new precision medicine tools to find the ideal treatment for you, suggesting that that precision medicine is potentially incompatible with the notion of practice guidelines. Now, the main effort came to naught. One doctor actually asserted adherence to a Maine guideline as a defense to malpractice. One of the reasons was that Maine, at the same time it adopted the safe harbors approach that it did, also adopted a pretrial screening panel requirement for medical malpractice cases, and a doctor who wanted to defend herself based on a practice guideline had to first make that argument to the screening panel. And if the screening panel disagreed with the doctor and said, no, the practice guideline is not a satisfactory defense, which the panel could do, then that finding of the panel could be introduced by the plaintiff in the subsequent malpractice case. And so doctors, being afraid of that result, simply didn't avail themselves of the defense. But recently, safe harbors, the interest in safe harbors has been revived. And organized medicine is essentially now, to a large extent, on the bandwagon. What James Todd said those years ago doesn't seem to be at least a concern, at least to some of them. This is H.R. 2300, introduced by now Secretary of HHS Tom Price. It would establish a safe harbors regime for practice guidelines that would be essentially submitted to the Secretary of HHS and then published. Unclear that HHS would have any authority to sort of question or challenge or revise the guideline. What HHS gets to do is to pick who gives HHS the guideline, where they come from. And this would essentially establish a conclusive presumption that, and again, could only be used one way. So I'm not going to take much more time, but the question is whether as an ostensible safe harbor or merely as a traditional evidence of the standard of care, what legal role will practice guidelines have in a world of precision medicine? Now, one possibility is that practice guidelines will be so generalized that they can apply to all cases, notwithstanding the growing sophistication of precision medicine. For example, my client is not liable. The practice guideline says wash hands before surgery. He washed his hands. Therefore, he has a safe harbor, conclusively not liable, even though the patient had some bad outcome from the surgery, right? That's, of course, silly. But that's one concern about using practice guidelines issued by the medical profession, and of course, who else is expert enough to do it, is that they may have a low, they may intentionally pick a low standard of care so that there's an enormous amount of safe harbor protection for their colleagues. The alternative, I guess, is for practice guidelines to cover all cases by being patient-specific. In other words, by reflecting all of the insights of precision medicine that might apply in a specific area of practice. No practice guidelines that I'm aware of are yet taking that approach to that degree. If anybody knows of them, let me know. The closest, I think, are the American Joint Committee on Cancer's guidelines for cancer prognosis, which is a very precision-like set of guidelines which requires relying on what we know about the individual characteristics, genomic characteristics of patients to make more accurate cancer prognoses. How would that factor into a malpractice case? I guess an erroneous prognosis, which was contrary to this very careful precision-based guideline, which led to harm from, say, improper chemotherapy regimen. Maybe that might be one way it might be used. But the more sort of fundamental question is precision medicine fundamentally at odds with the idea of using practice guidelines as safe harbors? Shouldn't there always be room for a fact finder to consider whether the patient's case is indeed different and not adequately represented or reflected in the recommendations of a guideline? Now, there are lots of other problems with practice guidelines that I won't go into at any length. They're plagued by ethical challenges. Back in the late 80s, the American College of Rheumatologists came out with a guideline that said that only board-certified rheumatologists are competent to treat arthritis. And the American College of Physicians shortly thereafter responded with their own guidelines saying, no, if it's simple arthritis, a general practice physician is also competent. So you have the potential for abuse as turf protecting statements. We know of the conflicts of interest on the part of those physicians who are part of the panels that craft the guidelines, and I can tell you more about that if you like. Recently, the Institute of Medicine and others working on practice guidelines have been working on ways to reduce the conflicts of interest, but they are still problematic. And finally, there's still scientific disagreement over what is the appropriate thing to do in a particular patient's case. And interesting question is, to what extent and how and when will precision medicine resolve those conflicts so that there's we don't have conflicting guidelines, which, if you're interested, go to the National Guidelines Clearinghouse online. The federal agency that compiles now has over 2,000 guidelines, and go to the synthesis tab, which will give you a list of the guideline areas where there are conflicting guidelines. One group says do A, and another group says do B. I will end here. I'll welcome any questions or comments, any further information, and thank you very much.
Is it my turn to ask a question? As a matter of cost control, reducing variability among medical practitioners is certainly one goal of the ACA, which was evidenced in the Accountable Care Organization and other demonstration projects that CMS is currently doing. How does that square with your comments of the last few moments?
I'm not
In
sure.
other words, if you have a payment policy, in this case, the federal Medicare program, which is encouraging standardization as one way to reduce variability among how doctors treat diseases, and are putting financial incentives and disincentives behind that, how does that square with the path that I think precision medicine is taking us?
I guess I would say that it is incompatible, but I'm trying to think of to what extent do the ACA programs do that. Do you have a thought on that? You have? Hang on, we're going to get your microphone.
Yeah, I'm Tom Wallace. I'm a professor of both law and medicine at the UK in Lexington. And I run the ICUs at the VA and also do stuff at the university. There is absolutely payment issues that come in. It's absolutely changed the practice. I'll give you one good example. Central lines, we put a line in a big vein that's either under your clavicle or in the side of your neck. And it used to be, CMS put in this thing called never events, and the VA is also following this. So what happens now, so when I was in private practice, 15 years ago, I did a lot of them under your collarbone, so-called subclavian vein, when I need large bore access for measurements and fluids and drugs that have to be in the central circulation. Then they came out and say, because the one problem with anytime you do that, you can get a collapsed lung as one of the potential complications. And the government said, oh, we're having too many, so we're going to put in a, quote, never event. So the people who got financially hit with this were both the doc and the hospital. And so now, in fact, the University of Kentucky has a rule that you cannot put a central line in unless you're using the ultrasound machine now, and then you have to use it in the neck, which is almost eliminated subclavian. So it's totally changed practice, and I don't think necessarily for the better, okay? So now we have people coming out don't know how to put in subclavian lines, and yet we know for infection control they're the better line. Now, because I've done so many over the years, I know who to put these in and who not to and which way to go, but that's not the way the trainees coming out now are. So this is a good example of that. Second is there should be an awareness that these guidelines also now should change over time, and when they get mandated by Joint Commission or CMS, particularly now they become almost like law. And there's a real question, one of it's a huge debate right now is giving beta blockers in higher risk patients after surgery. And there's more and more growing evidence that that shouldn't be the case, but you get dinged by CMS and by the others if you don't. So and there's also financial, incentives, that are tied to this. So unfortunately, this is what's happening, and it's really affected. In some ways, there was good intention, but it's also in some ways been a bad outcome because of it.
So I mean, a reference to, I was thinking quality metrics. I can see the tension, and of course they're linked to payment now. So I see what now, Peter, you were getting at. HR, what was it? 2300 doesn't have a mandatory updating requirement for the practice guidelines that will become safe harbors. It has I think it's every 3 years the secretary has to ask the submitting entity if there's anything new. So it's fuzzy about how good updating is, and one has to ask, is 3 years a suitable window? I mean, if medicine advances quickly, 3 years may be way behind the time. And I would, yeah.
I was going to add, because I also used to do consulting for the Joint Commission, and I would see this kind of problem rolled up. But I as a chief medical officer in a previous job, had to negotiate in a local level, for example, putting in stents in a carotid artery. Well, if you read the vascular surgeons, they say we're the only ones that know how to operate and can open the arteries, so we should be the only ones putting the stents in. If you get to the cardiologists, they say, well, we should be doing them all because we're the only ones that know how to put in these little tiny catheters, and we do it all the time because they put in heart arteries. And then you go to the interventional radiologists, and they say, well, we should be the only ones because we're the only ones that read how the films. So what I had to do is put them all in a room and say, we're going to come up with one solution, which I was able to do. But this is just a good example, and yet all three of those, their national organizations put their guidelines out and all put different things. And so this is one of the other problems is the self-serving nature of a lot of this. And then, I mean, another example is diabetic ketoacidosis. Endocrinologists almost never walk on the ICU. We as the intensivists take care of all of them. And and yet there's the Diabetes Association puts out this guidelines. And it's just, it's very interesting how some of this plays out. So it's just making people aware of.
And you also mentioned something which I didn't mention, and that is another source of guidelines are hospital-specific policies. And those, that's another source of conversation.
MACRA, I think we referenced that, but MACRA, which is the new law regarding how physicians will be paid, essentially has practice guideline types of standards. You have to report how often you do this and how you do that. Is that going to come in sort of as a safe harbor clinical practice guideline type of?
I don't recall that MACRA is directly linked to practice guidelines, but MACRA allows physicians to, contemplates physicians being paid based on meeting certain metrics or being part of, advanced, what's the term, ACOs and other advanced payment models, I forget the technical term. And so the question arises of what will the role of practice guidelines be in assessing meeting metrics. But that's, I mean, I have a question. Oh, do you have a follow-up?
Well,
okay. I have a question for
so
Carolyn.
never, putting aside clinical practice guidelines, will those standards of MACRA be used to avoid liability? In other words, if a physician, I think one of them is don't give antibiotics unless a patient comes back to you after 10 days of whatever illness. If a physician does that, do they avoid liability?
That's MACRA?
What you're looking at is HEDIS guidelines,
Mm-hmm.
that those are the quality metrics that we have to report. And, they're well meant, and they're really based, particularly the one on antibiotics, on things. But of course, what it's doing, I think, in the primary care setting is we're turning into, okay, we got to X this box, we got to do this thing, and the thought process, and again, getting away from the individualization of medicine is happening. But again, we are being held financially to these standards, and HEDIS lags terribly behind medical knowledge, so that we're operating, again, we're having to report and act upon this without really doing standard of care medicine at times.
So, one of the challenges, I guess I could recast my presentation as one of the challenges for precision medicine is to try to, as much as possible, make the, formalized recommendations about the proper practice reflect the findings of precision medicine initiatives. And not use them as conclusive standards of care. Anyway, because, I mean, I would imagine there is a patient for whom that antibiotic guideline is not appropriate. No? Just like there are patients who probably need more than 7 days of opiates after post-traumatic. Thank you, Governor Kasich.
Max, my question, from what I hear, I'm involved with doctors, the American College of Lifestyle Medicine, that have used plant-based nutrition to reverse and stop terminal heart disease, type 2 diabetes, obesity, okay? Most doctors don't know about this, and they oftentimes don't tell patients that, say, are scheduled for a cabbage. If you're not in an emergency situation, you can switch to a plant-based diet and you may not need a cabbage. Is one of the things that the American College should do is get involved with writing guidelines for these things and maybe present them to this national clearinghouse?
Well, you always have the question of, whose orthodoxy is driving the guidelines, right? And what do you do about alternative, approaches to treatment and so on? Yeah, we've got to go. Speaking of cabbage, it's lunch time. Dale.
Just a comment. I think reference was made to the fact that insurance in the non-Medicare population, insurance reimbursement and the standards that are identified and promulgated by insurance companies are very much driving the practice of medicine. And very often their standards lag the guidelines that are promulgated by professional organizations. And so it raises an interesting liability question that if, for purposes of obtaining reimbursement, I treat a patient with ABC, and as a matter of fact, my professional organization says the standard of care or the preferred guideline is DEF, what kind of a liability situation do I have if there's a bad outcome? Is that negligence?
It sounds like a rhetorical question to me.
Since that was not a question, I will take statements if you're not answering one quick statement.
Hang on, let's get you the poor Peter.
I think, because you were sort of asking where is precision, the field of precision medicine and thinking about this, and I can't answer that completely. And I think, most of my work with precision medicine really has been with the All of Us research program, which is in such an early stage of, we have not yet enrolled a single person, right? So I think we're in an early stage of thinking of that from the research perspective. But in putting on my NHGRI cap, some of the consortium that Ellen was talking about, like the clinical sequencing, exploratory research, and the eMERGE consortia, are starting to have these discussions for the genetic medicine part, to talk about what are the stakeholder engagement and what are the things that we need to be thinking about to have this question of guidelines. And so, again, precision medicine as a field is not just genetics and genomics, but I do think some of that is going to start to be worked through. And I do think it is a complicated way. It adds complications to guidelines to start having a not one-size-fits-all approach.
I just hope that the liability concern doesn't end up, doesn't create too much tension with precision medicine, so that we revert to one-size-fits-some medicine, which is what we've been practicing.
Let's thank Professor Melman.
Oh, yes.
And actually, Dr. Clayton as well.
Information about lunch, it's out there.
Okay.
It should be in an adjacent room. If it's not on one of the tables, you can eat it either in that adjacent room, or you can come back here. We'll resume at I think the schedule is 1:15, is that right? But, and would the speakers please just stay, because Brian would like to take a picture of all of us together. Thank you all for a very interesting morning, and I trust that Peter this afternoon will talk more about reimbursement and payment.
That's good. Very good.
And the attendees are some pretty impressive people.
Right. Got the right people in the room.
Not many of them, but they're good.
That's right. Well, sometimes you get a full house.
You get pearls.